Thank you so much, Evan. Can everyone hear me, by the way? Yeah, some thumbs up and back. Everyone, okay, perfect, great. So, first of all, it's an honor to be with you today. Thank you so much for having me. By way of quick introduction, I should tell you that I went to camp and I worked in camp my whole life. When it came time to graduate from college, I told everyone that I wanted to make camp my career. And everyone basically said, no, that's not possible. You need to go get a real job. So, young Isaac, sort of not knowing any better, I did the only reasonable thing that one does under such circumstances, and I went to law school. I started my legal career doing financial litigation at this Wall Street law firm in New York, and the whole time I was quite literally dreaming about camp. So to make a long story short, back in 2012, I left my law firm, and my wife and I launched what has become a large ACA-accredited overnight camp in Wayne County, Pennsylvania. And we also run a large retreat center as well. We still run that camp to this day, by the way. So I mention this just so all of you know I have some street cred, right? Like, I'm not just a lawyer, but I operate a camp and I'm in the trenches every summer alongside all of you. So when I was still practicing law, when I just started my career as a financial litigator, I was speaking to a friend and mentor. Some of you may know him. He said I'm allowed to use his name for this, Skip Vickness. So to those of you who know Skip, he said that he's met tons of lawyers who want to become camp directors, but not a single camp director who wants to become a lawyer. I don't know why. I may be the exception to that rule. So over my years in the camp industry, I noticed something. We have accounting firms that focus on camps, dedicated marketing firms that specialize in our industry, online training providers like Expert Online Training, specifically focused on camp, videographers who make camp movies, every other service provider you can imagine focused on camp, but there was no law practice focused on the camp industry. So a few years ago, this gave me an idea. And when I say a few years ago, that number keeps increasing, which is hard to believe because I still feel like I'm 25. But a few years ago, this gave me an idea. What if we started a law practice focused on the camp industry? So now, we did it. And in addition to running my camp, I'm a partner in Potomac Law Group. We have about 150 attorneys across various practice areas, and we represent dozens of day camps, dozens of overnight camps, and camp industry associations as well. So this kind of gives me a unique vantage point on the industry, both as an operator and as an attorney that represents a whole bunch of camps. So today, we are going to discuss our obligations to campers under the Americans with Disabilities Act. I thought that this was a fitting topic for today's session because I get so many questions from clients about the ADA and how it applies to the many different situations that they face with their campers. By the way, I should mention there's another attorney with us here today. Where are you? Are you in the audience? Yeah. Oh, hi, it's Karen Campbell, right? Hi, Karen. Hello, Karen. We will be taking a deeper dive into the ADA during our actual breakout sessions. So Karen is gracious enough to be with us today to lead a breakout session on the ADA. I encourage all of you to attend. And then later, I'm doing a session called Legal Questions Answered. And for now, we're talking about ADA obligations as to campers. In my Legal Questions Answered session, we're going to talk about them as to staff. I do want to mention one thing. This is a very big topic. Right now, in this brief presentation, we're going to cover sort of the tip of the iceberg as to the ADA and how it applies to campers. I write a blog. It is called the Camp Law and Finance blog. If you want to sign up for the mailing list, it's up here. I don't need to read it. You can see it on your screens. I wrote a detailed article, like a very, very long article about the ADA, how it applies to campers, and how it applies to staff. So if you have any questions about the topics we're covering, feel free to ask me, of course. I'm here. I'd love to talk to all of you. But also keep in mind, you can find all the substance in an article, and I have it pinned to the top because there are so many client questions in these topics. So if you sign up for the mailing list, I'll email you the article, or you can just go straight to the blog, camplawandfinance.com, where you'll find it. So, okay, the ADA is a federal civil rights law that protects people with disabilities from discrimination. I suspect all of you working in this industry know that. While the ADA's requirements are fairly straightforward, the complexity typically happens when we have to apply the ADA in the gray areas. The thing is, as camp professionals, we are fundamentally in the people business. We have hundreds of campers every summer. We have perhaps 100, 200, 300 staff every summer, depending on the size of your camp. Maybe more if you run multiple camps, in multiple locations. So this means that for us, the ADA gray areas are numerous, and they're constantly changing. So in this presentation, I want to discuss some of the key requirements of the ADA as they apply to campers. I hope that what we're about to cover gives you actionable guidance that you can actually implement in your camps tomorrow, right? That's my goal with these presentations, actionable guidance. I'm going to tell you some concepts that you should really keep top of mind when making decisions about campers with disabilities. And if you attend Legal Questions Answered later today, we'll begin with some introductory remarks regarding the same topics for staff. So Title III of the ADA prohibits discrimination against any camper with a disability. The ADA requires camps to provide reasonable modifications to campers with disabilities based on an individualized assessment of each camper. And we have an obligation to provide reasonable modifications as long as the modifications do not fundamentally alter the nature of the camp program or create an undue burden for the camp. Karen, how am I doing? Great, okay, you agree so far? All right, 2 lawyers are in agreement on everything I've said so far. So the requirements of Title III apply to what are called public accommodations, which is a term that's sort of specifically defined in the law, and I don't want to get too far into the weeds of what that definition is. For our purposes, I will just say this. Most non-religious camps are public accommodations. Religious entities are exempt from the definition, and this means that religious entities are not required to comply with the ADA as to their campers. The same principle does not apply as to their staff. By the way, religious camps should keep 2 points in mind. You may be subject to ADA-style obligations under your state law, and you're still bound by the staff provisions of the ADA, so you're only not bound by the camper provisions. Now, under the ADA, and this is a very important concept, the word disability has a specific legal definition. Disability is defined under the ADA as a physical or mental impairment that substantially limits a major life activity. A physical or mental impairment that substantially limits a major life activity. This means, and so many camps don't realize this, so here's an actionable takeaway that you can implement tomorrow. The ADA does not apply to every camper who requests a modification. Same goes for staff. It does not apply to every staff member who requests a modification. It only applies to people who have a disability as that term is defined by the ADA. So it often happens that camps receive an accommodation request, and they don't entirely know how to proceed, but they know that they're somewhere in the land of ADA. Well, I'll tell you, the first question you ask yourselves is, does this person requesting an accommodation actually have a disability as the term is defined in the law? And if the answer is no, then you don't have any obligation under the ADA to provide an accommodation, because the ADA only applies to people with disabilities. So with that sort of general overview, let's begin with a discussion of camp policies and your camper application. When it comes to camp policies, when it comes to your camper application, camps are not allowed to impose eligibility criteria that screen out campers with disabilities. So I'm going to say that again. Camps are not allowed to impose eligibility criteria that screen out campers with disabilities unless the camp can show that the requirements are necessary to provide the camp's services. So let me make this very practical. Clients often ask me to review their parent handbook, to review their camp registration materials. And in these materials, I see a very common statement across camps. I'm not going to ask for a show of hands. If I did, I suspect many of you would raise your hands. Many camps have a policy or a question that goes something like this. I, the parent, am registering my kid for camp. I hereby confirm that my kid is in good physical health and can participate in all aspects of the camp program, period. That would be an eligibility criteria that screens out campers with disabilities in direct violation of the ADA. I cannot tell you how many camp registration materials I've seen that have that exact statement. So here's another actionable takeaway for all of you that you can implement tomorrow. If you have that on your camp application, get rid of it. You can ask Karen what language to use instead. Now, when it comes to policies and camper applications, we are not allowed to impose eligibility criteria that screen out campers with disabilities. However, we are allowed to do so if the requirements are necessary to provide the camp's services. This language is a bit vague, but I will tell you that the Department of Justice puts out an excellent resource guide. Excellent, super accessible. It's not in complicated legal language. Anyone can read it and totally understand it. It is called the ADA Technical Assistance Manual. There's a staff version too, but we're not talking about staff right now. It's called the ADA Technical Assistance Manual. You can Google it. You'll find it very quickly. The Technical Assistance Manual gives many examples of ADA principles and how they apply to various hypothetical facts in that manual. So here's one DOJ example to illustrate the point that I just made about eligibility criteria. It goes like this. A cruise ship discovers that a person who uses a wheelchair has signed up to attend the cruise. They made a reservation. They plan to travel by themselves. The cruise line notifies this individual that she must bring a traveling companion. She must bring a one-on-one aide, or her reservation will be canceled. The Department of Justice tells us that requiring a traveling companion as an eligibility criteria violates the ADA, unless the cruise line can show that its policy is necessary for some compelling reason, and the implication is the cruise line would not be able to show that. It's an eligibility criteria that screens out people with disabilities. So now, you are allowed to have policies that go towards legitimate safety concerns. So here's another DOJ example from the Technical Assistance Manual. By the way, I suggest all of you should write down DOJ ADA Technical Assistance Manual. When you have ADA questions and you don't want to call a lawyer to resolve them, you can search the manual. It has really good examples. It's really clear, really accessible. So here's another DOJ example. A wilderness tour company may require participants to meet a necessary level of swimming in order to participate in a rafting expedition, right? Because again, everybody needs to be able to swim. And whether someone uses a wheelchair or doesn't use a wheelchair, it's irrelevant to this question of whether they can swim or not swim, but that's a legitimate safety consideration. By contrast, consider this example of what's not allowed. A recreation program prohibits people who use wheelchairs from participating in scuba diving classes. The director believes that people who use wheelchairs probably cannot swim well enough to participate. The DOJ tells us this is an exclusion of people with disabilities that violates the ADA. That's because people who use wheelchairs may be able to swim very well, and it is an unreasonable assumption that people who use wheelchairs cannot swim well enough to be in a scuba diving class. So you can require that everybody is able to swim well. That does not violate the ADA at all. You cannot require that nobody in a wheelchair is allowed to participate in this program because that is an eligibility criteria that screens out people with disabilities. So I want us to briefly go back to a point that I made. If you have a question in your materials that goes along the lines of, is your camper in sufficiently good health? My camper is in good health. I hereby confirm my camper is in good health and can participate in all aspects of the camp program. Cut that question. Just get rid of it. It's the best thing you can do. The other thing to keep in mind, the ADA does not allow us to make what it calls unnecessary inquiries about disabilities. If a camp requires a health form and questionnaire, which I'm sure all of us require a health form and questionnaire of our campers, then each piece of information that you require must be needed to ensure a safe experience for the campers. The criteria for inclusion of questions must be safety. The information on the health forms cannot be used to screen out campers who have disabilities. Now, at this point, let's switch gears. I want us to discuss the concepts of undue burden and fundamental alteration. So as I've already mentioned, just big picture to zoom out, camps must provide reasonable modifications to campers with disabilities unless a particular burden, the camp must still attempt to find a different modification that would meet the needs of the camper. So let's think about what these terms mean. What is a fundamental alteration? So practically speaking, a family comes to you, says, hey, camp, my camper has a disability. I need a reasonable modification to your program due to my camper's disability. You have an obligation to provide that modification unless the modification fundamentally alters your camp program or poses an undue burden, PS, or creates a direct threat, which we'll talk about in a few minutes. You have an obligation to provide that modification. So the question is, what is a fundamental alteration? Let's start there. At what point can you say, I cannot provide this modification because it would fundamentally alter my camp program? A fundamental alteration is a change that is so significant that it would fundamentally change the nature of the goods, services, or facilities that your camp provides. This is a very high bar. The DOJ often expects camps to jump through significant hoops to accommodate campers with disabilities and to modify the program for them. To help determine whether a modification would be a fundamental alteration, here's what I suggest all of you do. You should think about what are the essential elements of our camp program that are truly at the core of what we do. Changing one of those things would create a fundamental alteration of your program. However, changing the way your program typically runs to accommodate a particular camper would not be a fundamental alteration. The other concept here is the concept of undue burden. So once again, what world are we in here? So a family comes to you, says, hey camp, my camper needs a reasonable modification. I request ABC. You have to provide the modification unless it fundamentally alters your program, as we just discussed, or unless the modification creates an undue burden. So what is an undue burden? Let's consider this concept. Here are the factors to consider according to the guidance out there. So first of all, the nature and cost of the accommodation. Your financial resources as a camp, the number of employees you have who could potentially carry out the accommodation, and geographic considerations, such as whether you're isolated and in a remote location and far from medical care. The trend in recent DOJ settlements shows a very high bar to avoid accommodating a kid's needs due to this concept of undue burden. For example, this is very common. I'm sure all of you have had this. A family comes to you, says, hey, my camper has diabetes. I need the camp to administer an insulin injection to the camper throughout the camp day due to their diabetes, right? Very common request. I get specifically this, I see nodding heads. I get specifically this question from families, or not from families, from clients all the time, because this is what families are asking them. A camp might make the following argument. This is the argument that my clients often, they call me, they're like, but Isaac, right? We can't do this. Here's what they say. Number one, we don't have a nurse on site. We operate day camps all across the country or whatever it might be. We don't have a nurse on site at every particular location. We have one medical director who oversees all the camps, right? We don't have a nurse and our staff are not trained medical professionals. Therefore, we can't administer an insulin injection, right? You told us about this undue burden idea. This is an undue burden on us to administer an insulin injection. The Department of Justice says, no, it's not. There are numerous settlement decisions, right, where families have raised complaints about camps, and the Department of Justice settlement explicitly says camps must train their lay staff, their non-medical staff, to give an insulin injection to campers with diabetes. That is not an undue burden. The DOJ requires camps to jump through much greater hoops than that. I don't want to get into the weeds of this, but the undue burden, it really has to be something significant to meet this undue burden test. Now, keep in mind, the undue burden and fundamental alteration analysis goes to the question of whether you're obligated to provide a reasonable modification. Even if you cannot provide a reasonable modification, the ADA does not allow you to deny a camper with a disability the right to participate in your program. They have a right to participate. This is even if a kid with a disability cannot fully benefit from your program. So here's an example from the Technical Assistance Manual. This is straight from the DOJ. The DOJ tells us this: a person who uses a wheelchair wants to go to a group exercise class at a health club, right? So imagine there's a fitness studio, they're doing some group exercise class, a person in a wheelchair wants to attend. Let's say half the class is focused on squats and leg exercises. The DOJ tells us the individual cannot be excluded from the exercise class, even if they cannot do all the exercises and even if they cannot benefit from the class as much as other people who take that same class. Under the ADA, people with disabilities have a right to participate even if they can't fully benefit from a particular program. The only exception stems from legitimate safety concerns. So the DOJ gives another example. An individual who uses a wheelchair can be excluded from a basketball game because the wheelchair would create a risk to others in the basketball game who might injure themselves. Again, the DOJ's example, not mine, but that's what they say. So what this means for us, practically speaking, that even if a camp cannot provide a particular modification to a particular camper, the camp cannot exclude a camper with a disability unless the exclusion is based on legitimate safety concerns or unless the camper poses a direct threat to the camp. And let's talk about this direct threat concept right now. Another basis on which a camp can exclude a camper from their program is if the camper poses a direct threat to the rest of the camp community, to other kids, to other staff. And this assumes that the direct threat cannot be mitigated with a reasonable modification. So let me give you another example from the DOJ. By the way, all these examples are from their Technical Assistance Manual, which all of you have access to. It's a great, great resource. If you want to truly understand the ADA as to campers, you want to really, really understand it. I mean, of course, you should read my article in the Camp Law and Finance blog. But however, outside of my wonderful article, in all seriousness, you should read the Technical Assistance Manual. It'll take you a few hours to read. By the time you're done reading it, you will truly understand what the ADA requires of camps. So here's an example from another DOJ resource guide. This is a different guide, actually. And this example is about the direct threat analysis. It goes like this. It uses the example of a child care center, right? Very similar to camp, not quite camp, same concept. It's in question and answer format. Here's the question. One of the children in my child care center hits and bites other kids. His parents are now saying that I can't expel him because his bad behavior is due to a disability. By the way, how many of us have had parents like this, right? You can't expel my camper. Their behavior is due to a disability, right? They're hitting kids, hitting staff, biting people. No, it's a disability. You can't expel it. Here's what the DOJ tells us. So what do we think, by the way? Can we expel the kid? By show of hands, who thinks we can expel the kid? All right, I see a bunch of hands. You're correct. Here's what the DOJ tells us. The first thing the provider should do, the first thing in our case the camp should do, is try to work with the parents to see if there are reasonable ways of curbing the kid's bad behavior. The kid may need extra naps or time out or changes in diet or medication. That's our starting point. But if reasonable efforts have been made and the child continues to bite other kids, to hit staff, to engage in behaviors that are totally inappropriate in our community, the child may be expelled from the program even if they have a disability. The ADA does not require camps to take any action that would pose a direct threat, that would create a substantial risk of serious harm to the health or safety of others. So to zoom out for a moment, and I'm going to do a time check. We're good. We're good on time. To zoom out for a moment, a family comes to you, says, Camp, I need you to provide a reasonable modification for my kid. You have an obligation to provide that modification unless 3 factors stop you from doing so. Number 1, you don't have to provide a modification if it fundamentally alters your camp program. Number 2, you don't have to provide a modification if it poses an undue burden to your camp. And number 3, you don't have to provide a modification and you can exclude a camper if the camper would pose a direct threat to your camp community, a direct threat to other kids, to other staff. From here, I want to switch gears to address another really, really common question that I get from families. Why do I keep saying from families? From camps, from all of you. Camps often ask, can we charge families? Can we require families to pay more for a particular modification? And by the way, I've literally seen one of the big camp insurance companies. They have like an ADA resource guide. I think they've sunsetted this resource guide. They don't use it anymore, which is a good thing. But they had the wrong answer in the resource guide. Here's the answer. So, well, let me ask you the question. Can you charge families for a modification? Who thinks the answer is yes? No, nobody. Who thinks the answer is no? All right, I'm going to surprise you. You're kind of wrong and kind of right at the same time. That's a very lawyerly response. Kind of wrong and kind of right. So here's the deal. Here's how it works as to whether you can charge families. You'll be surprised by this. But what I'm about to tell you comes straight from a Department of Justice resource guide. This is not some other lawyer interpreting DOJ stuff. This is from the DOJ, right? Directly from a government resource. The answer is this. If a service is required by the ADA as a reasonable modification, then you cannot charge for it. All of you are right. If the ADA requires a modification, you cannot charge a family for it. Not allowed. However, if your camp chooses to go beyond what is required by the law, then you can charge for the service. So let me give you an example. Let's say a camper requires complicated medical procedures, not an insulin injection, something much more significant. They can only be done by licensed medical personnel. You don't have licensed medical personnel on site, or you don't have people with the right training. You might have a nurse who can't do this because it's quite complicated. In that circumstance, you may not have an obligation, maybe, you may not have an obligation to provide that modification to the camper. It might be a fundamental alteration. It might be an undue burden because of how much it costs, right? You might not have to do it. But you may choose to do it anyway. You may decide, you know what? We don't have to do this under the ADA, but we want to accommodate this kid. We want to make camp happen for this kid. Under those circumstances, you are allowed to pass along the cost to the family. And why? The reason is it's not a modification that you'd otherwise be required to provide. Your alternative to charging the family is saying, no, your camper can't come here because we can't provide this modification, right? Under that circumstance, you can charge the family. On the other hand, if a family is asking you for a simple medical procedure, right, such as the example from the DOJ, a finger prick blood test for a camper with diabetes. The camper with diabetes issues come up constantly in the ADA context, constantly. That's why so many examples are around campers with diabetes, but they transfer to many other medical needs. So a finger prick blood test, giving insulin injections, right? Things along those lines, you cannot pass along that cost to families. That is just a reasonable modification that you have to do. So by the way, another example of this is probably practical and relevant to all of you, and I suspect all of you have gotten this question. Let's assume a parent informs you, my kid needs a one-on-one aid. My kid needs a shadow. How many of us have had a family ask for this request without a show of hands, right? All the time. My kid needs a shadow to participate in the program. We need a one-to-one aid. If providing that shadow would be an undue burden or a fundamental alteration of your program, then you would not be obligated to provide it under the ADA. If you choose to provide the shadow anyway, then you can charge the family for it. But again, this is a very fact-specific analysis that depends on many, many different details. So this is not just universally applicable to every camp. Now, let me close with a final thought for all of you, and this is my last sort of piece of actionable guidance. Camps often ask me, what policies should we have in place regarding the ADA? First of all, I think it's a really, really important thing to have an ADA policy, one for campers and one for staff. I think that's critical. You want to have a policy in writing. Because here's what often happens, and I'm sure all of you have had this experience. A camp receives an ADA request from a family or from a staff member. They know, the camp knows, I am in some legal territory here. An ADA request has come in. I know the law applies. I don't know exactly how. I don't know what our obligations are. And now camp is about to start. You're busy. You're trying to ramp up. You're trying to open camp, right? Maybe you're already running retreats. You have some ADA request. You don't even know where to begin. And you find now your staff are like scrambling to figure out, what do we do? Here's the solution. As to campers, have a 2-paragraph ADA policy. 2 paragraphs, nothing complicated. 3 paragraphs. Have a brief ADA policy, and then when a camper says to you, hey, camp, I need a reasonable modification, you're no longer shooting in the dark. You're no longer saying, okay, what do we do? Oh no, we're in some legal territory while we have to operate camp. We don't know how to proceed. What you do is very simple. You look at your 2-paragraph ADA policy and you follow its requirements. And you simply do what it requires you to do. Same thing for staff. Now, what language should you use in these policies? To answer that question, and this is the final point I will make before concluding and allowing you to go to all the other exciting sessions we have, it is very instructive to look at Department of Justice settlement agreements with camps that violated the ADA. So what happens is, if a family alleges to the Department of Justice that a camp has violated the ADA, the Department of Justice will essentially conduct a mediation, right, between that camp and the family. It often results in the family agreeing to pay, the camp agreeing to pay a fine and to implement various policies, right? And then what happens, the DOJ has these settlement letters that are publicly available. And you can see what issues were camps accused of, right? What did families say the camps did wrong? And how did the DOJ respond? And in these settlement letters, I have links to them on the Camp Law and Finance blog, right? So you can find the links. In the settlement letters, the Department of Justice literally gives approved language for ADA policies. It says to the camp, as part of your settlement agreement, you will implement this policy, 2-paragraph policy on the ADA. You can just use that language. You don't need to recreate the wheel. You don't need to draft from scratch. You can simply look at existing settlement agreements and use the language that's already in there. I have links in the ADA article. So with that, I appreciate very much everyone's time, everyone's attention. I'm around. I'm doing a session a little later on employment law issues for camps. I welcome all of you to attend. And then I'm doing a session called Legal Questions Answered. There's another name to this session called Stump the Lawyer. So if you want to come and stump the lawyer, by the way, Karen, I welcome you to join my Legal Questions Answered session. That way they can try to stump both of us instead of just me. If you want to play Stump the Lawyer,